Morning, good afternoon, and good evening to everybody joining us from different parts of the world. My name is Holly Johnson, and I'm the Associate Director of Columbia Global Freedom of Expression. It's truly an honor for our Global Freedom of Expression to co-host today's launch of the book, Legal and Ethical Issues of Chilling Effect, together with the editors Gergely Gosztonyi and Gergely Ferenc Lendvai. The book was recently published by Springer, and we are delighted to help bring attention to this important contribution to global discussions on freedom of expression and democratic resilience. At Global Freedom of Expression, we monitor freedom of expression developments worldwide, and we do this through our case law database, which now includes more than 2,600 analyses of significant court decisions from over 130 countries. Our work examines how courts are responding to emerging challenges and then assesses how their judgments align with international human rights standards. Over the last several years, we began noticing that the concept of the chilling effect was appearing with increasing frequency across jurisdictions and legal systems. And although the chilling effect has long been recognized in international human rights law, it's become especially relevant in the contemporary moment as courts confront laws and state actions that may discourage journalists, academics, activists, civil society organizations, and increasingly ordinary citizens from speaking freely. And it's that growing concern that's precisely why our organization contributed a chapter to this volume, and we examined how the African, European, and inter-American regional human rights courts have addressed the chilling effect in freedom of expression jurisprudence. This book could not come at a more important time. Recent global reports paint a deeply troubling picture for freedom of expression and press freedom worldwide. For the first time in the history of the Reporters Without Borders World Press Freedom Index, more than half of the world's countries now fall into the categories of difficult or very serious for press freedom conditions. And then out of the 5 indicators used to assess press freedom worldwide, the legal indicator has seen the sharpest decline this year. At the same time, the 2025 report from VDEM Institute describes the current global moment as part of a third wave of autocratization, accompanied by growing censorship and repression of civil society. Against this backdrop, today's discussion is both timely and necessary, and we are very grateful to the editors, contributors, and participants for helping advance this urgently needed conversation. It's now my great pleasure to introduce our moderator today and co-editor of the volume, Professor Gergely Gosztonyi. Gergely is the head of the Digital Authoritarianism Research Lab at the Faculty of Law at Eötvös Loránd University, and his full biography is available on our website. So thank you, Gergely, for guiding today's discussion, and the floor is yours.
Thank you very much, Holly, and thank you very much for Columbia University for hosting this and the whole database issue that we are having, and I'm pretty sure that all of those who are attending and who are watching this live streaming later in this book launch could agree that your work in this field is just has an utmost importance. So thank you very much for having the possibility to have the book launch event with you and with your guidance. So when I will stick, or I will be very short because I don't want to waste anybody's time. When basically two and a half years ago, I had the idea. Oh, sorry about that. Okay, sorry. Terribly sorry. I'm in Dublin at the moment, and there is a class next to me, so I will move after that. So when basically 2 years ago, I had the idea to create or to examine the chilling effect. I'm a boring lawyer, so I have my idea was to look from very different perspectives. So not only from legal perspective, but to create an interdisciplinary work. And that's why we gathered, or we had the possibility to gather basically the best scholars around the world from legal perspective, psychological perspective, ethical issues and dilemmas. And it's very, very important for all of us. And when we were dealing with freedom of expression, it seems that there are two main fields or main areas
dealing with this question. The first is, of course, the one that we are mostly dealing with is freedom of expression and the chilling effect of freedom of expression. But the other one is getting more and more important. Not only, I'm coming from Central Eastern Europe, it's a crucial question there, but the academic freedom and the chilling effect in the academia is a growing phenomena everywhere in the world. Just think about what's happened in the US, just think about what happened in Asia, in Africa, and all around the world. So that's why this book is about these two main areas, and that's why I think it's very important to have all together in one volume. We have 22 chapters in the book, and it was a very tough call to choose the speakers because I had to bite one of my fingers because I loved all chapters and I loved all authors we had the possibility to work with. But we try to find three key issues and three key chapters in this field. We have three very respected scholars with us, but before going for that, I would like to present one of the leading European scholars in the field, Catalina Goanta, who is with us and who has the possibility to introduce shortly our book and have some opening remarks. So I give the floor to Catalina.
Thank you very much, Gergely, and thank you very much for your kind introduction, and also very much thank you to the Columbia Initiative on the Freedom of Expression. It is really my honor to be here and to offer some opening remarks on this book, and also in the meantime offer Gergely the opportunity of moving locations so that you can not have any kind of chilling effect on your interjections later on in the program. So thank you very much. And like I said, I'm going to take the next perhaps 15 minutes to give an overview of the book and also bring about some comments and some ideas which I tethered to the book with and I found to be a great perhaps opportunity to further the discussion that the book starts. Of course, once more, just congratulations to the editors and the authors for putting together such a fantastic collection that spans across continents, across fields, across issues, as we have already heard. And it delivers a clear and a very well identified research gap, namely that the chilling effect concept has this Janus-faced nature. It has so many complex parameters. And in the book, we see theoretical formulations, we see analyses of specific regulatory frameworks and sectors. We even see very specific references to a European regulation, and not only like the Digital Services Act. We see very different sectors, social media, journalism, art. And as was already introduced slightly by Gergely, there is a very wide range, an impressive range of jurisdictions, such as North Macedonia, the Philippines, Belgium, or Uganda. And I have to say, even though Gergely was already very modest and said, yes, authors bear the grunt of the work when putting together a collection of such wonderful papers and chapters, actually, editors have the fantastic responsibility of bringing together the collection. So this is a wonderful effort on your part and on your co-author's part, Gergely. In addition, what we see in the book in terms of the regulatory frameworks, the volume discusses the potential impact of many types of legal regimes on free speech. We have here examples that are very traditional, like legal instruments at the Council of Europe level or European Union level, African level, but also at national level and with different countries around the world. We also see the use and the reliance on case law, private governance, such as the private governance of social media platforms through their private contracting systems, but also very specific actions by governments. And we have seen in a few chapters examples from police raids and wiretapping as actions that the government can take to lead and that might lead to chilling effects. As the editors really point out from the early onset of the book, due to the popularity of the concept of the chilling effect and after its emergence from US case law and doctrine in the 50s and 60s, this concept has been embraced so widely and perhaps with too much generosity that we can say that it has become a victim of its own success. And so the collection embarks on a journey to further reveal the implications, the very complex implications of the concept that have really such great considerations for a very wide range of fields. And we already heard, for instance, psychology and ethics being some of them. So this is the journey that the book promises and that the book also delivers on, because the explorations in the 21 chapters draw from interdisciplinary insights that really allow us to better identify and visualize the missing dimensions in the conversation. So to avoid conflating other aspects that may play a role in freedom of expression and conflate them with the chilling effect. And I believe in the first chapter, where Gergely and his co-author also tried to create a framework to refer to these missing dimensions, they refer to, they even have a mathematical function, and they refer to this specific element of the missing dimension as an under-discussed error term, which is aimed at capturing the unobserved variables that are hard to prove empirically. And some examples include social stigma, harassment, narratives, fear, anxiety. So this is an example of a mathematical representation that plays a very important role in a causal link that has been central in the discussion around the chilling effect, because the idea that you can link a specific policy and a reduction in expression has been very much contested. And depending on the specific situations and cases, that this contestation might be more or less evident. I found this specific mathematical representation to be a very focused way to identify these different social, economic, and psychological complexities that are really inherent to the concept of the chilling effect. The book has such a rich thematic offer that it would be impossible to really do justice to it in the next, I believe, 10 minutes that I still have. So what I'm going to try to focus on right now is just a few comments that are grounded in my own research expertise, which is one of private law and platform governance, and specifically 3 points, which I think link very neatly to the general narrative of the volume. First of all, as we have seen in different chapters, there is a very specific link discussed between a legal framework and a chilling effect. And we see that this can be expressed in 2 ways. First of all, a very specific law, so positive law, that prohibits something. So we have a chilling effect around the perception of illegality and the behavior of citizens who think, okay, perhaps I shouldn't engage in a specific type of action because it is rendered illegal by the government, by the state, or it might be rendered illegal in a matter of time. And I think that in the chapter, in the first chapter, one of the examples to this extent is the Budapest Pride example, where in spite of political efforts to try to reduce support for LGBTQ public manifestations, the political and the lawmaking agenda very much did not go the same way as expected in practice, because citizens were only even more convinced that they need to go and show their public support. And that is also in spite of the law in question prohibiting the promotion of homosexuality, in particular, and the promotion of different types of events where LGBTQ communities could gather, would come with very specific fines. So that was an example where we see that we have a legal framework, and then do we have a chilling effect? And Gergely and his co-author said, okay, actually here we do not really see a chilling effect. So it is a very difficult causal link to establish. But at the same time, we can see that there can be a complex legal framework of different laws and enforcement actions that we can consider in this legal framework and its implications for the chilling effect. And I thought very long and hard whether to give this example or not, but I think that in a freedom of expression event, and also with the topic of the chilling effect, perhaps, and also Gergely was mentioning how this affects academics as a community, So I don't know about the multiple jurisdictions, but in the Netherlands, there are quite widespread discussions about participation in events in the United States. And then, for instance, there have been a lot of news items that if you have to be very careful what you write on your social media, because then you might not be able to gain entry in a country if you are going to be commenting negatively about the leaders of that particular country. So here we can see that in this situation, it's not necessarily a law, or there isn't any specific prohibition that academics would be reacting to, but a series of different legal frameworks, for instance, that can go into the direction of immigration, that could go into the direction of what kind of national security standards are in place in a jurisdiction at a given moment in time, and even dimensions relating to just what kind of practices and what kind of discretion is available in the practices of entering these legal frameworks. So, for instance, obtaining a visa. So here we see that if we want to investigate a potential chilling effect and say, well, is this fear leading to less criticism of certain regimes around the world? Because then you really want to make sure that you're not going to be placed on a list and still be able to travel internationally. Then we can see that we cannot really link such a potential reaction to one specific law or one specific legal framework because it is so complex. And I will come back to this complexity because I find it a very, very important element in this analysis. A second point that I wanted to make is that while also a lot of the chapters discussed very specific laws and specific legal frameworks, and I think that what is very important, and the book managed to bring this together as well, is the interaction between these legal regimes. So I will stay in my area of comfort, that is European law, and try to give the example of the Digital Services Act. And I think that the Digital Services Act has been mentioned and has been taken as a mascot for an instrument that is supposedly censoring speech. However, the DSA does not have this role, so it's not a type of speech restricting instrument, but it does have the role of bridging to other rules in the European Union that you could argue, if you're in favor of regulation or if you're a more anti or deregulation person, you could argue whether this is a legitimate regulatory recipe or not. But for instance, the DSA bridging to other fields of law, like consumer protection, if we say we have consumer protection rules that are going to limit the amount of manipulation in ads, that is going to be a limitation on content. The DSA is going to be a window through which this limitation on content is revealed. So what we have is really a tree with so many different branches and so many different fields of law that together build an effect that might lead to a perception of the public in terms of what can go online and what cannot go online. But if we zoom in and we look at the nitty-gritty elements, it becomes a very, very complex legal analysis, even for experts in the field. And lastly, my third point, and I think that the focus of so many chapters in the book on social media is really doing justice to this point as well. We see that there is a very specific role for technology in mediating not only the behavioral incentives, but also the consequences of the chilling effect. So there are so many chapters that deal with fake news and that deal with a lot of content moderation issues on social media. And these behavioral incentives, we see them play out, for instance, also in more commercial aspects of social media, such as content monetization. There are, and this is a very recent example, a member of the European Parliament also started an initiative against Meta in particular, because Meta's content moderation policies try to protect minors from the perspective of not allowing sexual content to be on its platforms. But at the same time, the actual interpretation and application of these policies have in practice limited a lot of content creators who focus on, for instance, sexual health, or sexual education. And this is something that I think is very important, especially if we add the monetization dimension. There's a lot of behavioral incentives for users to engage in speech or not, but then there's another layer of complexity when we say these users are also making money out of this speech. And then what kind of chilling effect role can we speak about if monetization is then affected through different interpretations of platform policies and the link between these platform policies and actual law. So overall, I think my question also for the authors and for the editors on the basis of these 3 points, generally speaking, would be what do we gain and what do we lose by calling these complexities a chilling effect? So if we see that, and the example that I gave earlier, we have a ramification of so many different legal regimes that could lead to the situation where maybe speech could be deterred. What do we gain by trying to frame that as a chilling effect and trying to analyze all of these unobserved variables, as you mentioned in the first chapter? And also, what do we lose by instead perhaps giving it another name or focusing on another phenomenon in this field? So these have been my initial remarks. I have to say that once more, this book has been a wonderful revelation and discovery for me. And although I'm not a freedom of expression scholar, and I very often look at freedom of expression and try to balance with other compliance obligations, because of course, things are very complex also when we look into the nitty-gritty details of the law. I have to say that I have found new confidence and new importance in the fundamental rights, and particularly the fundamental right of freedom of expression. So I would like to thank the authors and the editors once more for giving me the opportunity to have this revelation. Thank you so much.
Thank you very much, Catalina, for this amazing opening remarks. And it's really nice. I mean, to be very modest. I mean, it's nice to hear so many nice words about our own work. But I still go. Thank you very much. And it's not for the editors, but it's all for all the authors. And if we are speaking about the editors, I would like to highlight the work of my co-editor, because unfortunately he can be here, Gergely Ferenc Lendvai, who is an amazing colleague, and he did so many. He was such a help for me, and we did everything together. So with this possibility, I would like to use this to thank and to spotlight his work also. So thank you very much. And when you were talking, I was thinking. Of course, I'm dealing with EU law mostly as a European lawyer, and I'm always so fascinated about reading and hearing the US government's comments on the DSA and our European legislations. And okay, it could be good or it could be bad. So that's just a law. So it doesn't have to be normally good or bad. Of course, we'd like it to be good, but it has some flaws, of course. But it's so strange to hear the comments and read the comments about censorship and chilling effects, because it's such a different way to look for the same issues. And of course, we know that when we are dealing mostly about the freedom of speech in nowadays in our times, we are dealing with big American and Chinese platforms. We have to keep that in mind, and we have to keep that in mind, or we have to keep in mind that of course that affects and I think that affects chilling effect, that affects censorship and all these related questions. And I think that academic work, just like this volume, could help understanding each other better, and to understand the North American regime, the South American regime, the African one, the Asian one, and to see how we see, because I think that freedom of expression is that's why we are all here. Freedom of expression is important for us. Otherwise, I think we won't be taking part in any kind of webinars like that. So thank you very much, Catalina, and it's a truly great pleasure to have such a great scholar like you to be with us. So thank you. I can't say anything else. Thank you again. So now we are in the second part of our book launch event, when we have 3 authors from the book carefully selected.
to show their chapter in some minutes. So we asked them to do that in 10 minutes. So the first one is one of the leading scholars. I can't say anything else about the chilling effect issues, because Jonathan Penny wrote, I don't know, for 15 years. I mean, his work on chilling effect was such an inspiration for me when we started working with this field. So you have to know that. I already told you that, John, but you have to know that your work is amazing. And John is a legal scholar and the social scientist in Osgoode Hall Law School in Toronto, and he's an associate professor there, and also holds a York Research Chair in artificial intelligence, data governance, and the law. And then he's also for a very long time a faculty associate of Harvard's Berkman Klein Center for Internet and Society. And I would like to point out that his book on chilling effect, the newest one, the chilling effect, repression, conformity, and power in the digital age, which is a fascinating book, and I really love that, was just published last year, right? End of last year, in November, around November, if I remember correctly, at Cambridge University Press. So if you are interested in chilling effect, anybody who's hearing this webinar, read our book, of course, but I would like to suggest to read Jonathan's book, because that's just fascinating. So the floor is yours, John, and John's chapter's title was Chilling Effect Theory and Research as a Field of Study. The floor is yours, John, for 10 minutes.
Thank you so much, Gergely. So I'm going to share my screen. I've got a very brief present slide deck there, but before I do so, I wanted to first say I'm just absolutely delighted to contribute to this fantastic volume, and also be here with such a great panel of fellow contributors and experts doing such interesting and I think urgent and important research that's represented in this book. I wanted to first off thank, of course, Gergely for his invitation to contribute to the work, and his co-editor, also Gergely. I should say to thank the two Gergelys for their invitation and the work that they did to putting this together. It really is a monumental work, and really the breadth and the scope of the work that's represented there it's just fantastic. And of course, I want to thank the Columbia Global Freedom of Expression program for putting on this excellent launch. It really is a great platform to launch the book, and we thank you all for the efforts in putting this together. So with that, let me first share my screen and launch into my presentation. Let's see here. And let me know, everyone, when you can see.
We can see that right now. We see also a black screen at the moment.
Okay.
Oh, yeah, it's working now, John.
Perfect. Perfect. Okay. So thanks, everyone. I really, I don't know if I'll take up the full 10 minutes. Sometimes I say that in my presentations. I end up taking the full minutes here. But the way I wanted to frame both this chapter, but also this brief talk, as not really a presentation, more of a celebration, both of this fantastic collection of works on the legal and ethical issues of chilling effects, but also a celebration of this field that the book and all these great works are focused on, right? A celebration of chilling effects theory and research, really an area of research and study that's coming of age at a period where really it's needed most. at a period where I think that we've entered, where you have, governments and private actors who are weaponizing threats to chill and to repress in ways that we've not seen, and doing so in increasingly sophisticated ways. And so we're entering a period where the works of this book are so important, but as is this field of study. Now, where I ultimately go with the presentation or celebration will depend, of course, on what we're talking about. What is the object here? How do I define chilling effects? And of course, this is contested. There's some different ways of defining this term. The way I have often done in my work, and I know that this definition that I'll offer is broad enough that I think it can encapsulate a lot of the work that's done in this volume, is both thinking about the duality of this concept. That is to say, chilling effects is both a legal concept, right? That, at least in the modern era, emerges out of American First Amendment jurisprudence in the post-war period. And so it's entrenched in legal doctrine. And from there, it sort of travels to laws and jurisdictions abroad, including my home country of Canada, the UK, Europe, Asia, and now around the world. It's taken hold in ways that understanding has stayed with it to an extent, where that legal concept focuses on laws and statutes, and of course, how they have a chilling effect or discouraging effect on people's free exercise of their speech. Right? But underlying that legal concept is also a theory of human behavior. That is to say, a theory that in the face of these kinds of threats, in the face of a legal threat, in the face of a privacy threat, in the face of even a personal threat of violence, we have this behavioral tendency, and I talk about this in my own new book, to self-censor, self-restrain our behavior for self-protection reasons, right? And I think about the field or the area of research that's represented in this excellent collected volume and that's growing out there in this field is essentially works that explore that element, both the legal concept, the research concept, but also the impacts on human psychology, on human behavior, which makes this such a rich and, I think, interdisciplinary field. As Carlita's excellent comments at the outset really helped set the stage for this kind of work. But of course, in this chapter and in this presentation, I make the argument that chilling effects theory and research today is now a field of study. And, part of what motivated, there's different motivations that I had in making this argument. And of course, where I'll start is why this kind of argument matters. But part of this too is the fact that up until this point, the way often it's been treated by scholars and lawyers and researchers, the way they think and talk about this concept of chilling effects, both in academic studies, but also the way it's often referred to in popular cultural and mainstream media reporting, and by politicians who often invoke these kinds of concepts in relation to laws and public policy, is that chilling effects is seen as a subfield, or seen as a sort of more minor focus of study for lawyers who are concerned about First Amendment law or freedom of expression, or for privacy scholars who are concerned about privacy threats. And there's just sort of one sub-concept, maybe within a subfield, that's assumed within broader research studies within privacy or law or freedom of expression. And I think what we're seeing as represented by this volume and the research that's happening in the field is that's changing, right? Instead, we have a field that's matured, that's growing, that's evolved and really expanded, and is now far more rich and far more interesting and complex than in any other period. And it's become so at a time when the threats are suddenly becoming interesting, complex, and challenging. And this is what I mean, that the field of this area of research has really come to age at a critical moment when it's needed most. But you might be wondering, why does this matter? Right? Is this just all semantics? It's an area of research. What does it matter if we refer to this field of research, this focus, as a field of study, right? And of course, there's different reasons for this. We live in an era where we walk around with surveillance devices in our pockets of new kinds of technologies, facial recognition, bodily recognition, drone surveillance that are now being employed by governments and big tech to chill and manipulate and control our behavior in sophisticated ways we've not seen in other periods. And of course, new kinds of surveillance, new kinds of threats to speech, new kinds of threats to other kind of collective action, to democratic processes and opposition, and new governments, both in the West and around the world, that in my view are now weaponizing these threats in ways that we've not seen in previous eras. Right? And what I argue both in the chapter and in my book that Gergely mentioned, Ching's Repression, Conformity, and Power in the Digital Age, is these kinds of threats, when you understand their impact on people and on broader society, have a corrosive impact, not just on for freedom of expression, but are corrosive to both freedom and democratic societies. They have an impact, of course, on fundamental rights and freedoms, speech, and literally every other activity that's often tied to democratic processes, as freedom of assembly, freedom of collective engagement, freedom of association, freedom of speech. All of these are impacted and affected when these kinds of threats are being weaponized in order to chill those very rights and freedoms. And they also have corrosive effects on individuals, our personal development, how we engage with others around us. All of that is impacted, and the impact is profound. So it matters for these reasons, but it also reasons for sociological reasons, for the fact that if chilling effects research is now an official field of study with divisions and borders and important social structures and institutions, well, that also needs to be recognized just for historical accuracy, but also for both epistemological and prudential reasons. So when we recognize a field of study as such, we're doing so accurately, but with also the understanding is that when you elevate studies, when we understand that this is a focus of a collective effort among scholars, not just in one jurisdiction, but around the world, as we see in this excellent collected edition, this often leads to greater innovation. This leads to new questions being asked. It leads to new interdisciplinary work that's being done in the concept. And this is something that's been documented by scholars in a variety of fields who've asked this question. What does it mean to say something is a field of study, and what are the impacts? It can lead to greater impact, citation, but also new research, which is what we, again, need more than ever before. Part of how I define a field of study in this work, I rely on a variety of scholars across different fields. In particular, I lean on the work of French sociologist Pierre Bourdieu, who has done really interesting work in asking questions about what constitutes a field, who on Bourdieu's view necessarily possess their own social realities, power relationships that are constitutive of the field itself. In the case of a field of study, that would include any power relationships that permeate academic pursuits of a research object. Now, there's different ways, of course, to define a field of study. The way the Cambridge University Dictionary defines it, it defines field as a, quote, an area of activity of interest and study as the activity of examining a subject in detail in order to discover new information, or the act of learning about a subject, usually at a school or university. And I would add to that definition some of the key elements that Bourdieu often talks about, where he speaks to understanding not these sort of just technical boundaries of a field or a discipline, but understanding those power relationships, understanding the social structures and social realities and social context of a field, which I'll speak to just in a moment. So in the chapter, I speak to these three different fields of study criteria. One, you have a research object. Secondly, you have a defined body of knowledge. And thirdly, you have indicators of ongoing collective research efforts. And I think, in addition, one of the contrasts that I draw in the chapter is between both fields of study and disciplines. And I make the point that I think today, while chilling effects theory and research does constitute a field, it's not quite at the level of a discipline where you have defined often classes in a variety of jurisdictions at law schools or at universities, at different research institutes where we're learning specifically about this as a field. It's not quite arrived at, but maybe that's the next iteration of this wonderful field and the great scholars that are working on it today and tomorrow. So what is a research object of this field of study? And I mentioned it before, the way I've defined is essentially research and study that examine both the legal concept, the research concept, but also explore the impact of these threats on people's speech and behavior. Surveillance threats, privacy threats, legal, statutory, regulatory threats, government threats, public and private sector, all of that I would fit into this research object. And of course, there's a defined body of knowledge. You see it across different paradigms. In the chapter, I talk about three different research paradigms. The first being one that focuses often on the individual elements of the field. That is one that's really defined by the post-war period research of First Amendment scholars that focused really on speech, focused on the impact on the individual. Then you move into what I call the second era, which is I call the privacy era in the post 9/11 period, where researchers around the world are grappling with the expansive growth of national security surveillance to deal with new threats like the threat of terror after September 11th and the privacy threats and their chilling effects that happen, or the research that's done after that. But then lastly, I talk about a new era, what I call the interdisciplinary era. And I really think this book exemplifies this new era that's internationalist, it's globalist. It's not just tied to one field or two fields, law and privacy. It's really an expansion of researchers in a variety of fields. And lastly, I talk about in this book indicators of ongoing collective research efforts. And I won't spend too much time, but I have a few interesting graphs where you can see the usage of the concept of chilling effects across American English book works, British English language books and other works, but also other major languages. You see this concept is being increasingly utilized within published works across the globe. It's a growing field and really come at a time when it's so important. So let me finish there, and I really look forward to questions later. Thank you so much.
Thank you very much, John. And thank you very much for this, going through the ages and decades about how the research on chilling effect is changing and how we added more and more issues into this very important field. And I was thinking a lot when dealing with when editing with this book that of course the main question is, what is chilling effect? I mean, we can see it. I mean, it's not something like okay, I could touch it, and then most of the time it's really hard to qualify or quantify the chilling effect, and giving more interdisciplinary perspective for us lawyers, it's always handy, and I'm pretty sure it's the same for other disciplines to implement the legal perspective and the psychological perspective and all these issues. So if you are interested, and any of those who are listening are interested, what is chilling effect, then I think that you should read this book, and of course you should read
Jonathan's paper and then Jonathan's chapter, sorry, and to know about this growing phenomenon, which unfortunately, and I think I do agree with John that it's getting more and more important, and I have to say I'm a bit sad that I have to agree with that, because it would have been great if I could say that no, it's not an important issue at all, and that's an unimportant volume. But unfortunately, it's getting more and more important. So thank you very much, John, for your work and for presenting your chapter. And the next chapter we are having is another very hard issue, because when we are dealing with the chilling effect, when we are hearing politicians saying chilling effect, and we know that, oh, this will be bullshit. I mean, they have no idea. And the other thing is the fake news. So yes, when I hear from a politician they are saying fake news, I know it's something is going very, very crazy in that way. So that's why it's very important to combine these issues all together. And our next presenter is Elena Sherstoboeva. Sorry for that. It's really hard for pronouncing those Russian names. She is a wonderful lecturer in media law at Essex Law School, the University of Essex. And her research and expert project focus on studying and comparing media laws, policies in post-Soviet and Asia-Pacific context. And I think this is just like a fresh bread and fresh air for all of us in Europe, because we do understand what's going on and what's really happening outside of Europe, and merging these two issues is just amazing. And I also have to say that the chapter Chilling Effect and Fake News Lessons from East and Southeast Asia is co-authored by Valentina Pavlenko, who is not with us, because Elena is with us. But I think that it's worth saying that she was a co-author of this chapter. So Elena, the floor is yours for 10 minutes, and thank you very much for being with us.
Thank you very much, Gergely, for a very nice introduction, and thanks a lot for the invitation. Also, many thanks to Columbia Global Freedom of Expression for bringing this conversation together. I absolutely love you, and I will always recommend you as a platform to my students and colleagues. And yes, today I'm presenting our joint work, and I'm presenting on behalf of myself and my collaborator, Valentina Pavlenko, who couldn't join us today, unfortunately, because she's teaching. And I just, at the very start, I'd like to say that this chapter is very much a product of a wider academic community across generations and contexts, and I'm very happy that this chapter was released. Valentina and I began this project in 2020, so basically around six years ago, during the pandemic, when I was at City University of Hong Kong. I was working there, and at that time some of my students became my research assistants, and they were helping me gather and translate material from different sources, from a wide range of sources, from China, from Korea, from Taiwan, Japan, and beyond. And of course, I also remain very grateful to my students and my colleagues at CTU, my former colleagues, who organized the first pitching of this project, so first serious workshop, and convinced me and Valentina that this idea was worth developing. And Valentina herself is also my former student and now my current colleague, brilliant colleague, and also a reliable and fantastic collaborator. And I'm also very much grateful to Lorna Woods, Emeritus Professor of Internet Law here at Essex, who has been supported me so much. And so she, I would like to thank her for her intellectual generosity, for her encouragement and support. So she did so many reading of this chapter. And of course, I want to thank Gergely and Gergely, our fantastic editors, for your extraordinary work and conceptual ambition. So what our editors did, they took something that many of us had been using rather casually, the idea of chilling effect, and asked the obvious but surprisingly neglected question. So what exactly it is? So, and related questions: how does it work? Can we identify its mechanisms? Can we compare it across legal settings and contexts? And can we stop invoking it loosely and begin analyzing it properly? And that is, in a way, what exactly our chapter tries to do. So our central argument is quite simple. The chilling effect of fake news often stems not only from enforcement, but from legal design. In other words, we argue that badly designed fake news laws can chill lawful speech by design, not only by enforcement. Fake news laws are increasingly common across jurisdictions and widely criticized as chilling. That is, we saw this description everywhere. And what we hear much less often is which legal features actually produce that effect, and how those features or parameters interact, and how, if at all, that concept relates to the familiar language of legality, necessity, and proportionality in international human rights law. So one of these questions that really interested us was whether chilling effect is merely a striking metaphor, or whether it has a more precise legal meaning and analytical function. In other words, is there something in these laws, in fake news laws, that makes people afraid to speak? And our chapter tries to address this gap by developing a structured analytical tool that we called the Chilling Effect Rankings, or CER. We fully appreciate that chilling effect is not a neat mathematical object, and we had no ambition to produce some perfect or pseudo-scientific formula. That was never our point. But what we wanted to do instead, it was something more modest and we hope more useful. Some kind of a structured way of identifying and evaluating the parameters that matter. Parameters that framework that scholars, lawyers, and policymakers could actually use when arguing that a particular law or a particular policy is likely to generate chilling effects already at the drafting stage, before enforcement has ever even begun. So our focus was on legal design. And we chose East and Southeast Asia because this region combines legal and political diversity with a high concentration of fake news laws that were very heavily criticized, and also they had a lot of related regulatory instruments that makes it especially valuable for comparative analysis. And as we worked through the material, it became quite clear for us that not all parameters of chilling effect carry the same weight. Some were primarily, others were supplementary. And the most important point in our analysis and in our chapter is that clarity is central. Its absence doesn't merely amplify chilling effects, it generates them. And when legal terms are vague, speakers do not know with confidence what counts as punishable falsehood, what evidence is sufficient, and how the law will be applied. The result is precautionary self-censorship. People step back even before state has to act. In that sense, the law begins to chill not only through sanctions, but through uncertainty itself. Breadth does matter, but differently. So breadth expands the range of speech that is exposed to restriction, and a lack of clarity makes the boundary of that restriction hard to identify. So when the two combine, the chilling effect becomes especially strong. The third major factor is severity of sanctions, particularly where sanctions are harsh and safeguards are weak. Even where enforcement is limited, the very prospect of fines, imprisonment, correction notice, or blocking measures can make individuals and media actors avoid controversial but lawful speech altogether. In the end, legal uncertainty is what most powerfully cools speech over time. When we applied the framework across the 7 East and Southeast Asian jurisdictions, one result stood out immediately, and I think you can see it from the table as well. This table is a part of our chapter. So we clearly see that no fake news laws in our sample fully eliminated chilling effects, and that was not especially surprising. The intensity varied. In some jurisdictions, particularly Singapore, China, Malaysia, and Taiwan, the chilling dynamics were particularly strong. In others, such as Hong Kong, South Korea, and Japan, the effect appeared more moderate. But what mattered most to us was identifying the recurring legal mechanisms. The context and degrees differed, but the problem persisted the whole sample. And that, I think, is our most significant contribution. That's where our main contribution lies. So the deeper comparative lesson is that chilling effects are produced by recurring design choices. Vague definitions, broad discretion, weak safeguards, and sanctions that make the cost of misjudging legality too high for ordinary speakers, for journalists, for smaller media actors. So the broader lesson is not that all regulation of harmful falsehoods is illegitimate. Certainly that's not what we are trying to say. But what we are trying to say is that if legal clarity is sacrificed, then these laws do not simply regulate falsehoods. They basically recalibrate public discourse through that uncertainty. And so I think I should stop here. And our hope is simply that our CER will prove useful in practice, and that it will be taken up, will be refined, will be tested. And so basically, rather than sitting on the shelf. So that's it. Thank you very much for your attention. I'm happy to take your questions.
Thank you very much, Elena. And it was really lovely because we went from the idea of freedom of expression and chilling effect to the legal practice and how this is related to fake news in a bit outside of European context. And as we are in a very short of time, and we don't want to waste too much time on that, we are going for the next presentation. Thank you very much, Lena, for yours. I'm pretty sure that there will be lots of questions in the Q&A sessions for that. We are going for our third panelist, who is Protus Akwabi Murunga from Kenya, and he's a communication scholar. And his research interests include social media, gender studies, and crisis communication. And of course, it's all related to chilling effect. And it's a very, very interesting chapter, I think, and I'm pretty sure in that, because it's a very practical issue, how the the chilling effect has a professional effect and the psychological effect on the Kenyan journalists. So Protus, please, you have 10 minutes.
Thank you so much. I don't know whether to say good evening or good night because it's 12 a.m. here in Melbourne, Australia. My name is Protas. I'm a PhD candidate at RMIT University. I'm doing journalism studies, specifically looking at visual news production and consumption in rural Australia. Being Kenyan and being from a global southern country, and then coming into Australia has opened my mind into the disparities that exist in terms of journalism, how things work in Africa and how things work in the western parts of world, like here in Melbourne. So, like for example, the chilling effect has a major impact in the global southern hemisphere, like Kenya, more than it has maybe in the Western world. So I would like to start with an anecdote from Frantz Fanon, who argued that each generation must, out of relative obscurity, discover its mission, fulfill it, or betray it. For Kenya journalists, this mission lies in defending the truth, holding power accountable, and safeguarding democratic communication despite increasing political, economic, and digital pressures. This chapter examines how intimidation, harassment, censorship, surveillance, and online attacks threaten journalists' ability to fulfill the democratic responsibility. In Kenya particularly, each regime comes in with an agenda. This agenda is always poised at increasing the government's visibility. But the concept of state capture comes in, and whenever this comes in, the media is the first casualty. So people who go out there to do their democratic right in terms of being the fourth estate are only trying to tell the people what's happening from the government or even from the private sector. But most of the time, whenever they do maybe a story that negatively impacts the government, they are harassed, they become victims of government harassment. The study explores the growing chilling effect within Kenyan journalism, where fear of retaliation forces journalists to avoid, alter, or abandon sensitive reporting on corruption, governance, and human rights issues. This majorly affects female journalists who, being maybe mothers, wives, have a double responsibility to their bosses and to their homes. So most of the time they are become victims of online harassment, sexual harassment at the office. They become victims, people who are not promoted at the same speed with their male counterparts. And then journalists face multiple pressures, including political threats, newsroom intimidation, legal harassment, cyberbullying, and economic insecurity. These conditions create severe psychological consequences such as anxiety, emotional exhaustion, trauma, stress, burnout, and constant fear of professional punishment or physical harm. Female journalists, particularly, just as I said, experience additional gender abuse through online harassment, misogynistic attacks, and workplace discrimination. Professionally, the chilling effect weakens investigative journalism and encourages self-censorship, reducing the media's ability to challenge power and represent marginalized voices. We have had cases where investigative journalists in Kenya have been forced to flee the country. I know because I'm a former journalist, so my colleagues who used to do investigative pieces, especially touching the government's core activities, have been forced to flee because of intimidation and threats to their lives. Some of them are in the Western countries. So many journalists report avoiding controversial stories because of fear of intimidation, harassment, and maybe sometimes some are killed. Softening criticism or limiting investigations in order to protect their careers, livelihoods, and personal safety. As a result, public access to accurate and independent information becomes restricted, weakening democratic accountability and public trust in journalism. Most of the time when these journalists fear reporting on some cases, these stories become the norm. The evil in society is normalized because there is no one who can tell these stories to the public, because those tasked with telling these stories are targeted by government operatives. The study argues that when journalists are silenced, democracy itself is weakened. So I can say, like in these countries, the concept of democracy without the press is dead. I would like to say that maybe the chilling effect is a timely study that situates countries' media framework and how the general how the press works, and whether there is any country that has 100% media freedom. This is also subject to discussion. The research therefore calls for stronger legal protections, newsroom safety mechanisms, mental health support systems, digital security training, and institutional commitments to press freedom. Ultimately, the study situates Kenyan journalists as a generation confronting a defining democratic responsibility, whether to resist silencing and fulfill journalism's public mission, or allow fear and repression to undermine it. I had a very short presentation because of time. Thank you so much for listening.
Yes, thank you very much, Pratus. And I think that this is something that just gave a full circle to the chilling effect. How from the how we could go from just a theory to the very practice of this issue, and I think that gives us a whole picture of that. So I thank you very much for all three authors, and of course for Catalina for the overall one, and for the opening remarks. And I think that we arrived in a very good timing. So yeah, you know academia. So if you get the chance to speak, you speak. So that's a lovely one. And I'm one of those, so I know myself. So that's why I opened the floor for the questions, because we arrived to the Q&A. And if you have any questions to any of our authors and any of our presenters, then it's the time. You could ask it. We encourage you to ask it in person, but if not, then it's just absolutely okay to write it down. Yeah, just I think that we got hello there, and I forgot to say, sorry to say, that we have some of the other authors in the audience. So thank you very much for being with us, and thank you very much for all your work. I saw Mohor, I saw Carmen. So hello there, and thank you very much for being with us. Yes, I think I asked if there are any questions. Yeah, Catalina, the floor is yours if that's a question over there.
Thank you so very much. And I just want to say fantastic presentations by Elena, Protus, and John. And I'm actually going to build on Derek's question from the chat, because I think that the main question is, chilling effect is generally seen as something bad, right? So Elena, you were also saying right now we have this very, very clear messaging that if there's going to be a law, especially depending also on the nature of the state, right? So especially if we're speaking about maybe authoritarian regimes or cultural and political and legal environments where expression has been generally perhaps under threat. But can we also see that this chilling effect can be something good, particularly, and this is where I would add another layer to what Derek has been asking, particularly when we see that some of the mechanisms or some of the structures for expression are currently changing. And I just want to give an example that perhaps speaks to all of your presentations, the example of influencer journalists. So right now there is a very big trend to say, okay, I'm going to have a monetized channel on a social media platform. and I'm going to present the news. And then that can very easily go into conspiracy theories, into fake news that can be considered illegal content under more specific, secondary legislation. And then the chilling effect, or perceiving that maybe a framework, or whether it's the substantive framework or the enforcement framework, can be applied in such a way that it can be dangerous to engage in certain protected forms of expression. So, for instance, maybe journalists should have their own protections because of the integrity and ethics standards that are applicable to them. But then when you have other types of users who emulate or try to emulate these kind of standards, maybe a chilling effect wouldn't be bad. So thank you, Dirk, for actually thinking exactly what I had in mind as well. So I'm very curious. This is just a question to all of the speakers.
Yeah, and just an add-on about Dirk's question, because the question in the chat was that, okay, we are always talking about chilling effect as a negative idea, so it's something that is terribly bad. But could that be reframed, or could that be seen as something to repress, or better say, not to let hate speech and other illegal content that we don't like to have in our democratic conversation? So this is an add-on for Catalina's question, and I don't know who gonna start answering from our speakers. John, do you wanna grab the mic?
Sure, absolutely. So I think it's an excellent question, and it's something that I've also grappled with in my own work. I know that a variety of authors in this edited volume do so, and I'm sure Protas and Elena will also speak to this. Absolutely, one of the challenges I think about this new world, this new era of chilling effects theory and research, is the reality that it's not such a simple black and white world where we can simply say in all cases laws, regulations, even surveillance is inherently bad, and we can just simply say it's a threat that can lead to a chilling effect on speech and other kinds of key rights, and therefore we can write a book. Instead, we live in an era where I think we've recognized as a collection of researchers and scholars and understand that the traditionalist focus of chilling effects, that is simply looking at laws or statutes or regulations and then focusing on freedom of expression alone. Today, the threats have grown, the complexity has grown. And so now we understand that forms of hate speech, forms of online and offline threats and harassment themselves have a chilling effect. Right? And this is something that my frequent collaborator and colleague, Professor Daniel Citrin, has done a lot of work on, is the chill of forms of online abuse, and something that we've worked on and I talk about in my book and also in this chapter for this collective volume, is how we have to think and understand and ask questions to whether laws and regulations that can provide protection for certain groups that incentivize speech have a salutary impact rather than a chill, but a salutary impact that protect these groups that are disproportionately targeted for harassment, hate, and encourage those groups and individuals to speak and contribute, while at the same time, the research shows that in many of these cases, those kinds of laws have a trivial, negligible impact on other kinds of speakers. Then I think we have to be empirical, we have to be reality-based and say those kinds of protective laws actually have a role to play in increasing and promoting speech from a broader diversity of speakers. So I think the way we answer that is that acknowledging, yes, in some cases, a chill is not inherently bad. It can be positive if it's chilling net negative antisocial kinds of behaviors and is opening spaces for others to speak and to contribute.
Thank you, John. Elena, Protas, anything to add to this positive and negative issue of chilling effect?
Thank you very much, Gergely, and thank you very much, Dirk, for this amazing question. Absolutely fantastic and wonderful to see you among the audience. From my perspective, I would definitely differentiate between legitimate deterrence and chilling effect. So we were discussing this with my co-author quite a lot. So basically how we differentiate these two, because if we do differentiate them, then the concept of chilling effect, I believe, becomes very useful and can be operationalized in practice. So basically, I wouldn't necessarily call something that when a clear and proportionate law legitimately deter criminal hate speech, criminal incitement, or other types of unlawful harms. I wouldn't call it a positive chilling effect, to be honest. I would call it a legitimate regulation. Maybe I'm too boring, that's my legal mind. Chilling effect, as we use it conceptually, is something more specific. It is the deterrence of lawful and protected expression that must be protected, but it is not protected, and then it becomes silent because the law is vague, because the law is overly broad, unpredictable, backed by disproportionate sanctions. So the problem is not deterrence as such, but the deterrence of speech that should remain protected. And as for the question on the empirical part, I would really be very happy if maybe Protos could say about the empirical part, because, for instance, our chapter is basically doctrinal and quite boring, so it doesn't have an empirical material as such. We didn't collect interviews, etc. But of course, we fully understand that if we really want to test our CER framework, then perhaps the empirical analysis would be necessary. And I believe that the empirical analysis for evaluating chilling effect is something that is particularly complicated, especially when, for instance, you decide to use interview method, to evaluate how people feel, about that silence. So that's a very good question. So I hope that maybe Protos or maybe John can also comment on that. Thanks a lot.
Thank you so much. I think the chilling effect largely has a negative connotation on it, because it silences people. It creates fear in people, especially within the, for example, within journalism or communication. The chilling effect leads to self-censorship, where people are put in a situation where they fear talking about some things, because of intimidation. Sometimes because some journalists have paid their lives because they've been reporting or they're investigating about something. It may have positive connotations, like, for example, where it may deter the occurrence of unverified information, or maybe defamatory statements. And it may also lead to maybe media houses to strengthen their editorial oversight or gatekeeping processes. But at the end of the day, if a country is democratic very well, it has a lot of democratic institutions running, then the press must be at the center of it. And this press must be a free press. I doubt it may, let me say moderately free press, because I doubt whether there is any country that has 100% free press, free press where journalists can report on anything and everything. I really doubt that's a subject we can have a discussion. In terms of empirical data, I did a mixed method on my study. I did a survey and I did interviews, and the interviews were very good because it was rich information was gotten from the lived experiences of these journalists. They will tell you, and we will do it under our own terms. We will do it, and these people are telling us how particular personalities would send messages saying, leave this story alone. But also the survey was good because it was quite anonymous. So the people who are giving in information were anonymous. Some were even taking the time, because we were distributing survey questionnaire. Some would even take the time to write behind the paper what they are going through. So it was a very rich, I got very rich information about it.
Thank you. And we have two more questions from the audience, and I will change the order if you let me, because the first one is a pretty legal one, and to be honest, it's a luck that I don't have to answer to that, because I don't have an answer for that. Because the question is always how the courts define chilling effect. Oh well, that's a very open question, and we will see. So, but we are very lucky to have our colleagues from Colombia here, because they were examining all the jurisdiction of the Inter-American Court of Human Rights, and the question is that if I could add you, Anderson, Holly, or Estefania, or any of those who would like to answer or who would like to jump in. So what did you realize, or what did you find? So how the court could define chilling effect? So is there a threshold, or it just depends on about the giving judge and the judge personal impacts, or is there any kind of threshold to say that there was a chilling effect here, or there was not a chilling effect there? And I know the answer would be very, very different if we would take the European Court of Human Rights issues, because that's another issue. So Anderson, could I let you into that with the answer?
Yes, of course. Well, one of our finding was precisely that there is no one single definition in international human rights law of what is chilling effect. If you even look at the jurisprudence of the Inter-American Court of Human Rights, even the terminology, they have used different terminology to refer to the same phenomenon. But of course, if you do international human rights law, you will know that particularly the Inter-American system, but very similar with others, there is not an empirical or evidentiary strong basis for the claim of what is actually the chilling effect. Usually it has been connected to the identification of another violation of, it may Article 10 or 13, and be the article that prescribes, of course, the right to freedom of expression. And usually when you prove that there has been already a violation of this article, then you can emphasize on the impact to others. And I give you an example. In the Inter-American jurisprudence, there's these cases where, of course, a journalist or a judge have been sanctioned because of an expression. And the idea that the court has said, it has basically mutus proprius has identified and say, there is, if you sanction a journalist or a female journalist or a judge, you're also sending a message to all the other judges and journalists in the same situation as them, who will now refrain from doing their work or expressing their opinion, which are legitimate. So that is the understanding. One of the questions was in the European Court, for instance, was that some judges, they were saying we need more evidence to reach this conclusion, while others were, there is a principle of freedom of expression, and it's a logical conclusion for all of us that, of course, if you affect one category, you will at the same time affect the rest. So our take in our chapter is that it is a lot connected to the societal, or let's say the third collective dimension of freedom of expression. And because it's connected to that collective dimension, then you don't need an individual evidence. And that is kind of the conclusion that we can see and interpret from the jurisprudence.
Thank you, and yeah, that's something that we should all work for, that, because that's a very interesting issue. And as we are reaching our closing time, I have one last question, and this is for all of you, from Catalina to Protus. So all of you, if you would like to add your comments to that question, because it's a very open and the theoretical question, and it gives like that: has the digital environment impacted chilling effects in comparison to more traditional form of expression? And I know that the answers could go for a whole course at the university for 2 years or 3 years, so or a PhD dissertation, but just try to stick to a very short time. So any of those who would like to answer to that? I see John is nodding his head. So John, please.
Yeah, I'll be very quick. I mean, I think this is on both sides. I think the digital space has increased the scale and the impact of these kinds of threats, and their impact on speech and their impact on other related and core fundamental rights and freedoms. So in ways, it's two ways. And on the one hand, digital media, I think, has extended and created new platforms for speech and collective action and engagement the world over. But these same platforms have created new ways that we can be tracked, new ways that speech can be targeted and suppressed, and threats. The scale can be easily magnified. The same way speech is magnified, the threats themselves are too. But interestingly, and maybe this comes back to the empirical question, they've also created new opportunities to understand better than any before the impact of chilling effects. So collecting data before and after threats, which is what I've done in my own work with surveillance and other kinds of legal and regulatory threats. So it's created a different world, a greater impact, but also new opportunities for research. So I'll leave it there.
Thank you. Catalina, Elena, or Protus, anything? Catalina?
Yeah, so I completely, so this is a fantastic question, and a very nice way to close the webinar as well, with more food for thought and perhaps ideas for a second edition of this wonderful topic in an edited collection. So what I'm going to say is, I think that compared to what John was mentioning, digital environments are not just creating perhaps more impact or more harm, and also other opportunities, but it's also the scale is just unbelievably higher. And there is some work by Evelyn Dueck at Stanford University looking at content moderation, particularly from the perspective of the First Amendment in the United States. And I think that we also need to grapple with the question of, are our speech laws and our speech concerns actually made for this huge scale that speech is now operating with? If we're looking at social media platforms. And I think that when it comes to the scale, the problem here is, do we really, so freedom of expression means that everyone should be able to express themselves at every moment in time about everything within the limits of legality, which should be legitimate and democratic. But then if we look at this type of right, then the scale that comes out of this discussion perhaps becomes impossible to govern in such a way that it might be aligned with our current traditional understandings of freedom of expression. So that's just some echoes from literature on content moderation. I don't have an answer for how this should look like, but like I said, food for thought. Thank you so much.
Thank you, Catalina. Protus, Elena?
Yeah,
Anything
perhaps.
to add to that?
Thanks, Gergely. So I totally, completely agree with John and with Catalina. So basically, the digital environment should definitely intensify chilling effects. So because now we are more visible, more traceable, we can be reported, better investigated, and I think people should. I would expect that people should be more careful when they like something, when they repost something. And also because speech is cross-jurisdictional and you can never know how it affects you in a different jurisdiction, in a different country. What I wanted to say that basically what it means, the main implication from that is that so legal and other safeguards, they are becoming even more important. So that this that this intensification would be kind of like chilled. And what I also wanted to add is that it would be very interesting to have a study, to see a study on how emerging technologies and modern technologies can help overcome chilling effects. Like, for instance, anonymizers, VPN services, and if and to what extent these can really help make speech warmer, and so kind of like become these tools of deterrence for chilling effects. And also getting back to the question on courts, I also wanted to finish with a positive example that we bring in our chapter from Korea, when the Constitutional Court used the chilling effect as an argument to declare the censorial law, potentially censorial law, unconstitutional. And I believe that this is something in that way. So the court showed that the notion of chilling effect may be practically useful and should be better appropriated by judicial systems in order to protect rights and freedoms. So that's it.
Thank you. And before my closing remarks, Protus, your comment would be welcomed.
Thank you. I think the social media has, or the new media has opened up new frontiers for maybe contextualizing and understanding the chilling effect, because we have seen social media people anonymously publishing information that is inaccurate. It is defamatory. Information that is maybe could not have been published in the mainstream press. In as much as the platforms have opened the space for people maybe to publish their investigative pieces that would otherwise not be able to be published in the mainstream press, but also in terms of surveillance, it becomes a little bit tricky and a little bit hard for governments to maybe try to control what can be published especially in the digital space, because people can come and publish anything anonymously or using the pseudonyms. So it is like a catch-22 situation. It has opened new frontiers for understanding chilling effect, but it has also made surveillance very difficult.
Thank you very much. And I think that's a perfect closing for our 1.5. We were planning for 1.5 book launch. So it's my honor to finish this and give some very short closing remarks. So first of all, I would like, or I have to, I don't know about the order, but first of all, I would like to say thank you for all our panelists. So for Catalina, for Elena, for John, and for Protus, for being with us and sharing your thoughts and ideas, and then that was a wonderful event. So thank you very much. The second thank you goes of course, for Columbia University and the Global Freedom of Expression Initiative for Holly, for Anderson, for Estefania, and I saw Lautaro here, so thank you very much for giving us the possibility for hosting this event. And you could see in the chat, you could see all the links and just read and subscribe for their mailing list. It's amazing. I'm also subscribed. So yeah, it's a lovely one. We use that, and I agree with Elena that we are using, as a law professor, I'm using the database for all with my students. The third one goes, of course, for Springer. So thank you very much for trusting us and for going with us through this. Basically, that was basically 2 years. It's a long process. It was. So for trusting us and publishing this volume, and I really hope that seeing this, how many interesting issues could arise close or not so close to chilling effect. It's a wonderful field, and I think that all of us will continue. And just a personal remark after the end. So or at the end, I'm a huge fan of the Godfather movie. I don't know if you like it. I personally prefer the second one. So I think it's the time that after Godfather 1, there should be a Godfather 2. And after Chilling Effect 1, there should be a Chilling Effect 2. So I keep my fingers crossed for that. And I hope that some of the participants from the audience and some of the authors will continue this wonderful, lovely journey with us. So thank you, and buy the book, read the book, share the love. Thank you for being with us.
Thank you.
Thank you.
Thank you.